Now that we've got a few more people in, first of all, I'd just like to say a big welcome to our webinar today, and I would like to thank Girlings, David Redgate and David Morgan for putting this presentation together for us this morning. It's been obviously, we've got a week packed full of things that are happening over at BID. And one of those is actually taking place this afternoon at 5 o'clock. If you're not booked on, we are hosting a consultation on St George's Street and the work that they're proposing through Canterbury City Council. We have Richard Moore, who is the Head of Transport and Environment, talking, and it's an opportunity to ask questions. So if you do want to book onto that, pop an email over to myself after this session, and I can send you the link. Also, we not only are we doing this session with Girlings, we co-host our networking sessions in partnership with Girlings, and our next session is going to be the 21st of July. It's looking increasingly like it's going to be a virtual session, but so please watch this space, but we will keep you updated. And the other thing I just wanted to let you know before I hand over is that obviously we are putting climate change as a key activity over the coming years, especially with net zero by 2030. Now there's been some funding coming through, and the Community Renewal Fund bids are progressing. And quite a few of those include elements of business support to help businesses on their journey to net zero in 2030. So one of those proposals, they are currently looking for expressions of interest from local businesses. This is one that's being run through Canterbury City Council. They're looking for 30 local businesses to join an exchange programme, which brings together graduates, the creative graduates, with local businesses. And they're looking, as I say, looking for expressions of interest. If that's something that you'd be interested in, I again will send the details out after this session, and please let me know and I can put your name down. The project would involve free carbon literary training, a bursary for the project of £1,500, and they would put you in touch with photographers, filmmakers, musicians, poets as part of this way of being creative in promoting your business. So I will pass all of that over to you after this session. Now I have seen there are a lot of slides to get through, so I'm going to stop talking at this point. I will be handing over to David Morgan first for employment law. As I say, a recording of this session will be available afterwards, which I will share. And if you have any questions as both Davids go through their slides, please put them in the chat and we will come back to them at the end of the session. So David, I'm going to hand over to you and I'm going to put your slides on the screen.
Thank you. Thank you, Rachel. So I'm going to look at three topics this morning. The first is we will have a very brief look at the sort of recent changes to the furlough scheme. I'm not going to go into these in any great detail because I think people are now fairly familiar with furlough. It's been around for more than a year. But we'll just look at where we are at the moment. We're then going to go on to look at flexible working, which we think is going to be a hot topic over the summer months as people return to work, and contractual changes, which we also think will be something employers will want to think about over the coming months. And I think we're going to see a new, perhaps, system of working following COVID. So with regards, and the slide after that as well, please, Rachel. Thank you. So furlough was extended in the budget in April, March and April. It's been confirmed it's now extended until the 30th of September. We were perhaps expecting an extension to that further following the announcement on Monday that restrictions are going to stay in place until July, but there seems to be quite a lot of resistance from government. So we are currently looking at the end of the furlough scheme on 30th of September. And from July 2021, employers are going to have to contribute 10% of a furloughed employee's pay. So the employee will still receive 80% of their pay, but the employer will only be able to recover 70% from the government and will have to top up by 10%. And for August and September, that increases to a contribution of 20%. I think this is following the announcement on Monday that restrictions are going to continue into July. I think this is going to put some employers into a more difficult place than they would have been, because they're going to have to start topping up employees' wages when perhaps those employees are still going to have to stay at home and remain on furlough. Moving on. The job retention bonus scheme and job support scheme that we were sort of talking about at the end of 2020, both appear to have been mothballed. You'll remember that the job retention bonus was a £1,500 bonus that was going to be payable to employers if the employees remained in employment in January of 2021. The extension of the furlough scheme in October has put that on hold, and it now looks likely that they may not be introduced at all, given that the furlough has been extended for almost another 12 months over its the position we were in this time last year. I think it is likely that furlough may be extended if there are further lockdowns. I think if we go back from the current position to being in lockdown again, rather than where we are at the moment, I think it is likely that furlough will be extended in those circumstances. I'm not sure if there's going to be any extension to it with restrictions as they are at the moment, where a lot of businesses are actually opening back up now. Other changes that have come in the last sort of 3 to 4 months is that employers can no longer claim furlough during an employee's notice period now. So once notice has been given, employers can no longer claim furlough from HMRC during that period. This is going to make
I think I might press the wrong number.
This is going to make quite a lot of. This is going to make quite a lot of changes, because what we saw in September and October last year was a lot of employers were sort of foreseeing the end of the furlough scheme and starting their redundancy consultations so that employees could serve notice while they were on furlough. That's not going to be the case this year, and so therefore I think if employers are going to make redundancies, perhaps it is going to be successful in delaying that. Another point you need to remember is to manage holidays during the furlough period. I think a lot of employers are forgetting to do this. Employees are accruing holiday all of the time that they are on furlough, which means that if you don't manage holidays, they are going to return to work in October and potentially have 5 weeks of holiday to take in the remainder of the holiday year. Employees can be required to take holiday and they can remain furloughed while they're on holiday, but you will have to pay up to 100% during the holiday period. However, that's potentially better topping up now than it is having at the end of the furlough scheme, the employee comes back on full pay, you can't claim it back at all, and they're then entitled to take their annual holiday. So although you can require them to take holiday, you need to look at your contract of employment to see how much notice you have to give. And if there's no mention of how much notice the employer has to give in the contract of employment, the default position is that the employer must give twice the period of notice as the period of leave to be taken. So if you want an employee to take 1 week's leave, you have to give them 2 weeks notice of that. Okay, so moving on to flexible working. We are sort of at a bit of a watershed moment with flexible working, I think. And there is likely to be an increase in requests for flexible working. A lot of employees who have been forced to work from home by COVID are actually going to quite like that arrangement and perhaps will want it to continue, where the employer may want them to go back to the office at some time in the next 3 to 6 months. There was already a big trend towards flexible working prior to COVID, but obviously COVID really accelerated this last March and April. And in April 2020, 86% of the people who were working from home were doing so because of COVID. So we saw something like a 4 to 5-fold increase in the number of people who were working from home and who were forced to do so by lockdown. Moving on. So what does flexible working actually mean? Well, it means any work pattern different to your existing one. It can mean different or reduced or compressed hours. So it can mean a change in your working hours, a reduction in your working hours, or perhaps working 40 hours in 4 days rather than 5. It can mean home or remote working, or it can mean job sharing, essentially going part-time and the employer recruiting another employee to fill the gap. Now, the law on flexible working says that any employee with more than 6 months service has a statutory right to request flexible working, and this is all in the Employment Rights Act 1996. Now, this isn't a right to flexible working. It's just a right that an employee can request flexible working, and it places a duty on the employer to consider that. Now, there is, I think, going to be a lot of conversations between employers and employees over the coming months about flexible working, and a lot of those will be less informal than a written flexible working request. And it might be that employers and employees will come to an arrangement about flexible working without having to go through this statutory procedure. However, if the employer rejects that informal request, the employee, if they've got more than 6 months service, does have a statutory right to make a formal written request and for the employer to request it. So what the law says about flexible working requests is, firstly, they must be in writing, and they must set out what flexible working the employee has requested, whether that's working from home and for how many days or how many hours they want to reduce to and what their working hours will be. And the receipt of a written request triggers a statutory 3-month decision period. So the employer has a duty to consider the request within a 3-month period. That can be extended by mutual agreement, but if the employee doesn't agree to extend, then the employer must come to a decision within 3 months. And the law says that the employer must consider the request in a reasonable manner. And if the employer is going to refuse the request for flexible working, it must be for a reason which is set out in the legislation. And moving on to the next slide, there are 8 statutory reasons to refuse a flexible working request. So the employer can refuse on the basis that it's going to incur additional costs, or that it's going to have a detrimental effect on the ability to meet customer demand, because the employer can't reorganize work amongst the existing staff, because the employer is unable to recruit additional staff to fill any gaps that might be made by a part-time working request, because he thinks it will have a detrimental impact on the quality of the work produced or the business performance, or because there's simply an insufficiency of work during the period the employee proposes to work. So say, for example, you have an employee who makes a request to change their hours from 10 a.m. to 2 p.m. every day, and they want to change from 2 p.m. to 6 p.m. If the period of 10 a.m. to 2 p.m. is very busy for the employer, but the period of 2 p.m. to 6 p.m. is very quiet, then the employer can refuse on that basis. And the employer can refuse on the basis of planned structural changes if there are other changes going on in the organisation that would impact the business. So employers can't simply reject a flexible working request on principle. They can't just reject a request because that's their policy, is that everybody will work from the office or from the place of business. And they have to deal with requests in a reasonable manner. That's what the law says, but the law doesn't say what a reasonable manner is. There's no legal definition within legislation of what a reasonable manner is, but there is some guidance in the ACAS statutory code of practice and the guidance on flexible working requests. And what the ACAS code on flexible working requests says is that employers should handle requests and communicate decisions promptly. They should hold a discussion meeting in private with the employee and allow the employee to be accompanied to that meeting. So the employee can be accompanied by a trade union representative or a colleague in the same way that they can be accompanied to a redundancy consultation meeting. And ACAS say that the employer should consider the request carefully, looking at the benefits of the requested changes for the employee and the benefits for the business, and weighing those against any adverse business impact. And in doing so, the employer must not discriminate unlawfully against the employee. So as I've said, a policy of not allowing flexible working on principle just because you want people to work in the office, it may not be one of the statutory reasons for refusal of a flexible working request, and therefore it may be an unfair decision in as far as it doesn't comply with one of those statutory reasons. And it may be indirectly discriminatory, especially to women. Women have been legally recognised as taking greater responsibility for childcare. I realise there's some debate about whether that should be the case or not, but it is recognised in law that it is a fact that women do take greater responsibility for childcare. And therefore, women are more likely to make flexible working requests in order to fit around that childcare. And therefore, not allowing flexible working on principle might be indirectly discriminatory to women, because the refusal of a flexible working request may have a greater effect on a woman than it would have on a man for reasons of childcare. So if an employee can show to an employment tribunal an employer has not acted reasonably in dealing with the request, the tribunal can order the employer to reconsider the request and award damages to the employee of up to 8 weeks' pay. However, we are currently in a position where the 8 statutory requests are fairly wide, and it is fairly easy for employers perhaps to assert that they can't implement flexible working because of one of the statutory reasons. And the current position as well is also that the employment tribunal cannot consider if the employer's decision itself in saying that flexible working would impact on one of the statutory reasons is unreasonable. All the employment tribunal can really do is look if the employer followed the correct procedure. So employers must follow the fair procedure, and the employment tribunal can haul them over the coals for that if they don't. But what the employment tribunal are very reluctant to do is go into the business reasons behind a request. The general principle is that employers are fair to run their business in the way they feel is right, and provided that the belief that the flexible working request should be refused for a statutory reason is held reasonably, the employment tribunal will not really go into too much detail about how the employer came to that decision and whether it's correct from a business point of view. So COVID means there is likely to be more flexible working requests in the future. Lockdowns have imposed flexible working in some form on very large numbers of employers and employees. And some of those employees and indeed some of the employers will want to continue to work flexibly rather than return to the office full time. I think the feedback I'm getting from employers and employees is that whilst the limited return to the office is seen as a good thing, they will want some form of flexibility moving forward if that is possible. Now, traditionally, employers have relied on reasons such as business efficiency to reject flexible working requests. They've always said, no, we think this is going to impact the business. But the problem employers may now face is whether they can still assert that, where we now have a 12-month track record of people perhaps working efficiently from home during lockdowns, and perhaps people working from home having not the effect on the business that employers may have thought it had. My feedback is that most people are working from home reasonably effectively and doing a pretty good job of it. However, even before COVID, there was a trend towards flexible working. The government, even before the first lockdown, had announced plans to consult about making flexible working a default option, i.e. bringing in legislation to make it more difficult for employers to reject a flexible working request. And you also have to consider that this isn't just a legal issue. Many companies are open to flexible working, and employers who maintain a rigid approach to their work patterns are perhaps going to lose out on the best candidates. I think a lot of people are perhaps wanting to only return to the office on a part-time basis. We're seeing a lot of employers are saying now that employees will work flexibly, but they will work predominantly from the office, perhaps do 3 days out of 5 a week in the office and 2 days a week from home. And I think that companies who aren't open to that sort of flexible approach perhaps will find themselves losing out in attracting the best recruits who may want to work from home on at least a part-time basis. So we're going to move now from flexible working into looking at contractual changes. Flexible working are really targeted at employees who want to change their working terms and conditions. But there is also perhaps going to be employers who now want to make changes to their employees' contracts moving forward. There will be employers who have had people on flexi furlough, perhaps for 80% of their time, who simply when people do return to work after July or after the end of the furlough period in September, will not have enough work available and will perhaps want to try and get some of their employees to work part-time. So we've seen that statutory requests are a formal way of requesting flexible working for employees. But what can employers do when they want to vary the working hours? It is open to the parties. Sorry, can we take a step back there, Rachel? Thank you. It is open to the parties to simply agree to vary the contract of employment to reflect new arrangements if they're in agreement. So if an employee is happy to vary the contract and accept the terms that the employer is proposing, the employer can simply write a letter or draw up a new contract which reflects those new arrangements, and the working relationship continues on the new terms. But what we're going to look at is what can employers do if the employee is a little bit less flexible and won't agree to new terms that the employer may want to impose. So as we've said, employment contracts can't be varied unilaterally by the employer unless there's actually a right to vary a particular term in the contract itself. And if there isn't a right to vary the contract actually written into the contract, then variation can only be made with the consent of both parties, otherwise it's a breach of contract. There's also a legal principle that if the parties are going to vary the contract, then some form of consideration, some form of compensation must be given for that contractual variation. That would normally be the case in a commercial contract, even if it's a peppercorn consideration. But continued employment is considered sufficient in most circumstances for the variation of employment contract, that the value of the continued employment to both the employer and the employee is considered sufficient consideration for contractual changes. The exception to that is perhaps where the changes are very detrimental to the employee, and you may want to perhaps pay maybe £50 in compensation for the employee accepting the contractual terms, just to give them a little bit more legal force in situations where the employee is perhaps a little bit apprehensive about the changes, or where the changes are considerable for the employee. If the parties are in agreement after some consultation, then the contract can simply be varied. I would recommend that that's in writing, and do check your contract, because a lot of employment contracts will contain a term that say any amendments to the contract must be in writing. And in any case, it's best practice to have it recorded in writing, just so the parties understand exactly where they are. And so you've got some proof of the agreement to the variation in the future in case anything goes wrong. So, as I've said, changes can't be forced on an unwilling employee without a risk of the employer being in breach of contract. If you do simply enforce changes on an employee and tell them they must change their working hours, or they must reduce their working hours, for example, then that can entitle the employee to resign and bring a claim for constructive unfair dismissal, because you will be in breach of the terms of the contract yourself. Now, many employers will have a general term in the contract of employment which purports to allow them to vary any of the terms of the contract of employment at their discretion. There will be a term in the contract of employment that says the employer can make reasonable change to any of the terms of your contract of employment. Do take care with those. They do not do what they purport to do. And the courts are very reluctant to allow the employers those wide freedoms, and they tend to be fairly strict. So you wouldn't, for example, be able to rely on a clause that say you are allowed to make any changes at all to the contract of employment in order to move the employee from being a full-time to a part-time worker. The courts do not consider that to be a reasonable change, and they do not consider that to be fair, and they will not allow you to make such changes on the basis of a wide variation clause that we see in a lot of contracts. But the courts will allow employers to rely on specific variation clauses where the right to vary and the effect is clearly set out. Generally, these are found in the place of work clauses. So the place of work clause will typically say you will work at the company's offices in Canterbury City Centre, or any of the company's offices in East Kent, for example. Now, because that's a very specific clause that says we can vary the workplace and you provide the area in which the workplace can be varied to, the courts are likely to consider that that type of variation clause will allow the employer to vary the place of work. And for example, if the working hours clauses say that you will generally work 9 till 5, but you may be also required to work at any time between the hours of 7 a.m. and 10 p.m, because the employee can understand exactly what the hours may be varied to when they sign the contract, the courts are also more likely to uphold that type of variation. But even then, the courts will require the change to be reasonable. So for example, if you've got a place of work clause that say you will work at the company's offices in Canterbury or any of the company's offices in the UK, the courts may not consider that moving an employee from Canterbury to say York, which is a considerable distance, would be reasonable. It's about what is reasonable to the employee and what perhaps was foreseen by the parties when at the time they signed the contract. But in any case, the first step is always to seek the employee's agreement through consultation. That's always the best course of action, and try and get them to agree. But what if the employee won't accept a contractual change? Where do we go from there? The first option is to impose the change on the contract and see how the employee reacts. Now, this risks having to deal with a grievance from the employee, because by imposing the change on the employee, you're in breach of the original terms of the contract of employment, and potentially it risks the employee bringing a potential constructive dismissal claim against you. The employees can also work under protest. They can say, well, I will work these hours, but I'm working them under protest until we can come to some other arrangement. But employees do need to take care with that, because if they work under the new terms for more than, say, 2 to 3 months, the courts will deem that they will have accepted the new terms by working under them. And the employee can simply refuse to work under the new terms. So if you wanted to change them from full-time to part-time, and they continue to turn up for work as if they were full-time, then you would have to make a decision about whether or not you're going to dismiss them, in which case they can then bring a claim of unfair dismissal. The other option that is open to employers is to do what we call a fire and rehire, and this has been in the news a fair bit over the last few months due to British Gas. Effectively, fire and hire is where you terminate the employee's contract on notice and you offer them an immediate re-employment on new terms. And in this case, the continuity of employment is preserved, because they cease work for you, say on a Monday under the old contract, and they start work under the terms of the new contract on a Tuesday. So you give the employee notice and wait and see if they're going to object to the dismissal and if they're going to accept the offer of new work. This is a dismissal. It is the termination of their contract of employment, and therefore if the employee doesn't accept the new terms of the new contract and doesn't turn up for work under the new contract, they can bring a claim for unfair dismissal. You may also engage a duty to collectively consult the employees if there are 20 more who are affected by the proposal. So if you propose that you're going to terminate the contracts of more than 20 employees and offer them new contracts, you do have a duty to collectively consult them in the same way that you would have a duty to collectively consult if you were making 20 or more employees redundant. And that can be quite onerous in that you have a minimum of a 30-day consultation with them. But in any case, even if you don't have a duty to collectively consult, you should consult employees in a manner similar to consulting about redundancy before terminating that contract and offering a new one. If you do dismiss, the dismissal will be by reason of what we call some other substantial reason. So it's not a redundancy, but there is a catch-all category of dismissals called some other substantial reason, which this would fall under. And the employment tribunal will go on to look at whether it was fair to terminate the contract of employment in all the circumstances. And they will look at the business need underlying the changes, the procedure that you followed, and you really do need to consult very thoroughly if you're going to dismiss an employee for this reason. The effect of the contractual change on the employee. So it might be more reasonable for an employee to reject new work if the changes are very detrimental to them, if there's a significant pay cut or a significant change in work. The tribunal will look at the balance of interests. They will look at, are the changes so critical for the employee, for the employer, that they have no option other than to do this? Or on the other hand, is it a fairly minor change for the employer that they could have got around some other way? And they will also look at the number of employees who accept or reject the change, which will give them a sort of a reasonable idea of how whether, you know, if the majority of employees accepted the change, that would tend to suggest the changes were reasonable, and perhaps that a dismissal was fairer than it might have been had every employee rejected that change. Fire and rehire, like I said, it's the subject of debate. British Gas have recently dismissed hundreds of engineers who refused to sign new contracts. There was a significant proportion of the engineers who worked for British Gas who were fired and rehired this year. And employers do need to be very careful. The courts are very, very strict, and it is a very tricky thing to do, and to consult properly with employees. And currently there is government consultation underway as to whether legislation is necessary to govern the ability of employers to fire and rehire. Generally, looking at contractual changes, you do need to be aware of potential discrimination issues that might arise from changes in the same way that they might arise for flexible working. Again, do be careful when dealing with women who might have childcare responsibilities about making changes to their working hours that might have an impact on that. And I think that's where we are with contractual changes, and I'll now pass over to David for his section of the talk.
Thank you, David. Last year, I gave a presentation to the bid on the impact of coronavirus on commercial leases. And so the first half of my presentation is going to be a bit of a summary of that. And then the second half is running through some considerations for taking a new lease with the benefit of hindsight of that coronavirus impact. So that's the first set of considerations for the impact on leases currently. So we move on to the next slide. Forfeiture for non-payment of rent. So Section 82 of the Coronavirus Act 2020 prohibited enforcement for right of re-entry or forfeiture of business tenancies for non-payment of rent. It didn't cover other breaches of lease, just non-payment of rent. Rent could also include buildings insurance and service charge. There was also a restriction on the use of the commercial rent arrears recovery, which is seizing the assets of a tenant if they've not paid the rent, and restricting circumstances in which winding up petitions can be presented against companies. Now that was a temporary prohibition for tenants' benefit, and that comes to an end at the end of this month. So following that, landlords can again forfeit leases, take possession, and take possession of the premises, also possession of possessions that belong to a tenant. Currently, landlords can sue for damages or sue for non-payment of rent, so that's not been stopped. If we move on to the next slide. Now, to try and stop that, the government brought in a voluntary code of practice for commercial property relationships during the pandemic. And the government's intention was that the code is for tenants who are able to pay their rent in full should continue to do so, whereas those businesses that cannot pay in full should communicate with their landlord and pay what they can. And landlords should also provide support to businesses if they're able to do so. But that is a voluntary code. Now, the case below that, which I'll simply refer to as Commerce Real for obvious reasons, in that case, the tenant hadn't paid rent and the landlord was able to obtain summary judgment against them for the rent arrears, which at first you'd think would go counter to the code. But in that case, the tenant was criticised because they made no attempt to communicate with the landlord or offer to pay any amount of rent. They treated the code as something of a get out of jail free card, which it isn't. And so they did end up having to pay the rent. The next slide. So the landlord has some considerations to make if a tenant comes forward and says, I can't afford to pay the rent. So they don't have to agree any concessions, but not agreeing a concession may result in the tenant going insolvent and the landlord being left with a premises without a tenant. I think courts generally have not looked favourably on landlords who've not been flexible. And landlords should consider accepting rent payments monthly rather than quarterly, postponing rent payments and collecting rent later. The last consideration for landlords is that even if they're not paid a service charge, some services still have to be provided, such as buildings insurance. So yeah, buildings insurance. Next slide. Further protection given to tenants, which will be relevant currently, but also going forward, where the lease has protection of security of tenure under the Landlord and Tenants Act 1954. The landlord cannot propose a lease renewal, or can oppose lease renewal if the tenant has not paid the rent on quite a number of occasions. Now, the 2020 Act brought in a provision that will not apply during the period set out there, I think 26th of March last year up to the end of this month. So if a tenant's not been able to pay the rent during that period and then seeks to have a lease renewal, the landlord cannot object to the lease renewal on the basis that they've not paid the rent. Now, if the lease renewal comes up next year or the year after, then the tenant can still rely on this, but only for rent that was not paid during that period of 26th of March 2020 to 30th of June 21. Next slide. There are some insurance considerations. As mentioned before, the landlord has to continue to insure the building. Now, the tenants might have something called business interruption cover, and if they have, it might be worth them speaking to their insurer to see if a claim can be made. This is if they've had to close during the lockdowns, and it might give them some sort of compensation. For landlords, they might have something similar called loss of rent insurance, which is a bit more common. So if landlords not been able to recover rent from a tenant, it might be that their loss of rent insurance, which is usually a bit of a bolt on to the buildings insurance, that might be able to compensate them. Next slide. Now, last year, I think a lot of insurance companies were criticised for not paying out on business interruption insurance. And the FCA brought a test case to the High Court, which then eventually made its way up to the Supreme Court. And they tested 21 types of policy that covers business interruption insurance. And they found that I think for 14 of those, there was a a good chance that payments could be made. Now, I've not going into detail of all of those, but there are a couple of links there to the FCA website, where if you think that you might have a claim, you might want to follow those links and investigate for yourself. Now, not part of leases, but something that's been helpful for cafes, bars, restaurants, is the ability to have a pavement license and trade outside whilst they're not been permitted to trade inside. Now, traditionally, pavement licenses have been granted by the Highways Authority, which in Kent is Kent County Council. And in addition to the license, you would have needed planning permission. But recently, that's been reformed so that you don't need planning permission, and the license is granted instead by the local authority, so Canterbury City Council. Now that process all comes to an end in September, at the end of September, and we revert back to the old system of Kent County Council issuing the license and requiring planning permission. Now, for any businesses that have enjoyed their license of late but didn't have one before, they might like to consider applying for planning and for a license with KCC to start from October. Next slide. Now, I set out here some of the considerations and procedures for the pavement license, which I'm going to skim over. You can read through the slides later if you wish, or a lot of this information has actually come from the Canterbury City Council website, so it's all on there if you was interested in the current license. So next slide. And next slide again. And next slide again. Right, sitting out license. A bit like a pavement license, but sitting out license applies where the land on which you're going to put your tables and chairs is not highway, it's not pavement, but it's private land. And so you'd need the permission of the landowner to put out your tables and chairs. Now that might be the tenant's existing landlord, and sometimes that permission would be in the form of an easement in the lease. But often landlords prefer to grant a license because they have a bit more control over the tables and chairs in terms of when they can be put out. The permission can be withdrawn at short notice. Now that might be through a change of tenant. They don't want a new tenant to operate the sitting out license, or it might be that they have other tenants nearby that complain that it's impacted poorly on their enjoyment of their own property. So sit out license offers more flexibility to a landlord. An easement, I think a tenant prefers. Next slide. Things to consider for a tenant is that whilst the license is more flexible in the landlord's favour, it does have the benefit of not attracting stamp duty land tax. So that is of a benefit to the tenant. License is generally only for a number of hours of a day. If it was 24 hours and the tenant had exclusive possession of that land, then it can be deemed to be a lease rather than a license. In the license, the landlord can also set out the permitted use. So it might be that it's obviously tables and chairs. It doesn't have to be tables and chairs. It could be A-boards or signs or a combination of furniture outside. For a shop, it might be permission to put out goods for sale. Next slide. Okay, so with the benefit of hindsight of what's happened in the last year, I'm going to run through some clauses that could go into a new lease if you were to take in a lease now. That would give you some flexibility and a better chance of dealing with the impact of another pandemic, if there was one. So starting with the rent suspension clause. Okay, so the rent suspension clause covers a situation where the government imposes a mandatory measure that requires the tenant not to use the property for the permitted use in the lease. Where applicable, requires the landlord to prevent or restrict access to the demised property so that the tenant cannot use the property for its permitted use. Since the lockdown, well, before the lockdown, I hadn't seen a rent suspension clause in a lease, I have to admit. Since the lockdown, acting for tenants, I've managed to get a clause put in on 2 occasions. And I guess there's definitely a benefit for the tenant, not so much of a benefit to the landlord, because it means they're not going to be paid rent. So whether a rent suspension clause goes in to a new lease or not, I guess depends on negotiating power. The clause can be expanded to cover other epidemics or pandemics. Consideration needs to be given to whether the tenant sublets part of the premises. So you could see the situation if part of the property is sublet and that subtenant has a different use to the head tenant. It might be that subtenant is able to continue to trade because of their different use. So some consideration needs to be given as to whether the head tenant gets a full or partial suspension of the rent. The benefit of the clause also is that it protects the deposit if a deposit's been paid, and it protects a guarantor if there's a guarantor guaranteeing the payment of the rent. So moving on to break clauses. Now, break clauses are common in leases, but they come with some conditions attached. So in order to exercise a break, the rent has to be paid up to date. There are no breaches of tenants' covenants. A notice period is served. Normally that's 6 months, but it doesn't have to be 6 months. And the tenant has to vacate both in person and also removing their possessions by the break date. Now, break dates can be one or more fixed dates during the term. More beneficial to the tenant, particularly in light of the coronavirus pandemic, would be to have a flexible break date that can be exercised at any time. Now, that currently is quite rare. Again, I guess it's a case of negotiating power. If the tenant's able to negotiate a flexible break, then that's going to suit them better, not so much the landlord. Now, leases can also include a landlord break. So it might be that if the landlord wants the premises back, they think that they can let the premises to someone else who is able to pay the rent. Maybe they have an alternative use that won't be so affected, then they could exercise their break. So flexible permitted use. Now the planning uses have recently been changed to make it easier to change between planning uses. Leases are generally a bit more restrictive on the permitted use. So it might be the use is of an office or as a cafe, but generally you can convert from office to cafe or cafe to office without the landlord's consent. Sometimes consent is required in the lease, sometimes it just prohibits any change at all. The landlord doesn't even have to consider whether it's reasonable or not. Now, a more flexible permitted use will benefit the tenants. It will allow the tenants to be adaptable, so they could change how they use the premises. That's quite relevant at the moment, and some uses are still locked down and some are not. Also, a more flexible permitted use may be attractive on an assignment of a lease. So if the tenant wants to assign the lease to a new tenant, and the new tenant can see that, okay, the current use is this, but I can change it to what I want, then there's going to be a greater range of tenants willing to take that premises. Now, the permitted use should not extend beyond the planning use. Otherwise, the tenant could find themselves in breach of planning law. And a landlord may resist a wide permitted use clause, as certain uses may devalue the property or may devalue the landlord's neighbouring property. Also, if the landlord has numerous premises, they often want to avoid neighbouring tenants competing in similar businesses. So another consideration is the rent clause. Now, the majority of rent clauses in leases are for fixed amounts agreed at the outset, and the rent may increase from set dates via some mechanism of rent review. That might be a rent review where the tenants agree the new rent. It might be that it goes up with inflation or by fixed amounts or fixed percentages. Less common, but worth considering in light of the coronavirus, is a turnover rent clause. And for this, the tenant will pay a rent geared to a fixed percentage of its gross turnover. And then have a base rent as well. The base rent is conventionally benchmarked to a fixed percentage of the market rent. So here we've got the example of 80%, but it could be a smaller amount. Over and above the base rent, the tenant pays by way of turnover rent the amount by which the fixed percentage of gross turnover exceeds the base rent. The landlord is sure that it will always receive at least the base rent, whether that's 80% or another figure, and may receive more if the gross turnover is high. So the tenant and landlord share the risk and reward of the marketplace. The amount of gross turnover will be certified on an annual basis, but the tenant will make payments on account of the turnover rent. So the next consideration is security. Now, that's not security guards, but security in the form of rent deposits or guarantees. So landlords will often require a tenant to give security when granting a lease, particularly if the landlord considers the tenant to have poor covenant strength. For example, if this is the first venture of the tenant, they've got no trading history, they consider to have poor covenant strength. The security can be in the form of a rent deposit. That's often 3 to 6 months rent, but could be any amount. Personal guarantee, particularly where there's a company, a landlord will insist that a director gives a personal guarantee. And sometimes they'll ask for a cross-company guarantee if the tenant is in a group. A guarantee would cost nothing initially, which is attractive to tenants, but the guarantor is to pay the rent if the tenant does not or cannot. And guarantors receive no protection or assistance from any government scheme during the pandemic. A rent deposit has to be paid on taking the grant of lease and will typically be equivalent to 3 to 6 months rent plus VAT, if VAT is charged, that is. But it could be for any amount the parties agree. Now, a tenant is required to replenish the deposit if it's all used up. So if rent has been paid for some time, the landlord uses the deposit. The tenant is supposed to top up that deposit, but currently I think the view is that once that deposit's all spent and the tenant's in difficulty because of the coronavirus, then it's not likely that the landlord would take possession because the deposit is down to nothing. Okay, so I've put together some questions that come up. The first one is in relation to a shopping mall lease. So with these leases, often there is a requirement on the tenant to keep the premises open during set hours on set days. So the question is, what are a landlord's options with a view to enforcing a keep open covenant in the lease? So a landlord would not be entitled to a mandatory injunction to force a tenant to comply with a positive keep open covenant, but the landlord may still be entitled to damages for the breach of such a covenant. Now, the damages are that often with these shopping mall leases, you do have a turnover rent. So if the shop's not open, there's no income through the tenant, and so the rent that the landlord receives is also less. Hence why there's damages on the landlord. There may be significant evidential problems in trying to show that the alleged damage was caused by the shop's closure, as opposed to the effects of COVID-19 more generally, and the earlier enforced store closures and continuing restrictions on movement and social distancing in particular. So if the store's permitted to be open, but it closes, it can be hard sometimes to show that the loss of income is down to the closure and not down to people choosing not to shop or travel restrictions. Where there is no current government requirement for the tenant's shop to be closed in light of the pandemic, then in principle the tenant will need to comply with any keep open covenant under its lease. Where it is not financially viable for a tenant to keep its shop open due to the COVID-19, however, it may be that the courts would be sympathetic to a tenant where the landlord seeks to enforce the keep open covenant, especially bearing in mind the measures currently in place for the protection of commercial tenants. Okay, so the second question, will a break notice served on a landlord be validly served if the landlord's office might be empty due to the lockdown? And the answer is not clear, has not been tested at court. If a contractual notice is served at the correct address, which is generally the address in the lease, in accordance with the provisions of the lease, it may still be validly served even if the addressee was not there to receive it. But there is scope for argument about this. So, for example, if the addressee has explained that the premises cannot and will not be occupied during the lockdown and provided the sender with alternative contact details, the addressee might try to argue that the sender is stopped or prevented from relying on a notice sent to an empty office, or that the sender has acted in bad faith. essentially knowing that the landlord's not there, but knowing where they are. As a general rule of thumb, it would be prudent to err on the side of caution and try to avoid the argument to begin with. That may point to serving by alternative methods and at more than one address. Next slide. Question 3, which I think is the last question. Does the tenant need to serve a Landlord and Tenants Act 1954 Section 27 notice to terminate the tenancy if it's not quite cleared and vacated the premises? So Section 27 is where the tenant wants to vacate the premises and break the lease. If the contractual term of the lease has ended and the tenant has, to all intents and purposes, vacated, but there are some belongings left at the premises, it might be worth checking if the lease may already provide for the possibility of the tenant's chattels or fixtures remaining at the property after the expiry of the term. If the lease doesn't include any equivalent term, then the landlord tenant could agree terms for the tenant to attend and collect its chattels and fixtures once the restrictions have been lifted. So essentially making clear that you do intend to vacate, but for practical reasons, those items have got to come out later. Whilst the tenant may not have given vacant possession, the tenancy may no longer be continuing under Section 24 of the 1954 Act. In any event, on the basis that the tenant is not in occupation for the purposes of its business, as it may no longer satisfy the qualifying criteria. And consideration should be given to a tenancy at will. So that would work on the basis that both parties agree that tenancies come to an end, but the tenant is allowed to continue in occupancy for a period of time under a tenancy at will, which can be terminated at short notice. This will have the benefit of certainty to both parties and also the benefit to the landlords that they will still be able to collect insurance, rent and business rates will be paid by the tenant whilst the tenant's still in occupation, albeit under a tenancy at will. And I think that brings us to an end.
Thank you so much, David.
That's okay.
That was a lot of slides and a lot of information. And just to remind everyone that's on the call, we will share those slides. So I'm aware that there were some links on some of the slides. We'll put them into an email so you've got easy access to them. Thank you so much to both Davids for your time and for the presentation. We are a little bit over time. I'm aware it's 10:35, so if anyone needs to leave right now, you absolutely are welcome to head off. However, if anyone has any questions, please take yourself off mute and ask those questions to David and David. And does anyone have any questions?
Yes, hi. It's Remy from SE1 Media. Thank you both for the presentation. I have a question for David Morgan on Furlough. You mentioned about the flexible working, and I have two questions actually. You give an example, and I'm actually intrigued by the example you gave. If an employee asked to work 40 hours in 4 days, would that be a reasonable request?
So you mean if an employee asked to reduce their hours from 8 hours a day over 5 days to 10 hours a day over 4 days?
Yeah.
I mean, in terms of a flexible working request, it potentially, yes, it's a reasonable request. It really depends on the nature of the employee's work. I mean, do they, for example, someone who is manning a help desk where the help desk needs to be open, say Monday to Friday, 9 till 5. No, it's not potentially not a reasonable request in those circumstances. Because the employer can rely on the fact that work's not available perhaps outside of those hours for the employee. But if, for example, they're in a role where they can manage their workflow over the week and they're pretty much left to do that, and they can get all the work that they need done in that week, then yes, potentially it is a reasonable request. Whether it's reasonable for the employer to have to accept that is dependent on the circumstances.
Yeah, so based on that, that leads on my two questions. Would an employer be able to suggest that kind of flexible working? And I'll just follow with my second question. You say we have to do new contracts if we do agree on this kind of flexible working. Would we be able to just add sign an addendum to the contract, or do we really have to do a new contract?
No, I think for example, if the employee is going to work, if basically you want the office to only be open 4 days a week rather than 5, if the employee agrees to that, then I think a simple letter confirming the new working arrangement is fine. What you need to look out for is does your contract say that changes must be in writing? If so, you must send something in writing, but a letter would be adequate. I mean, if the contract changes were more complicated, then it might be appropriate to issue a whole new contract. But no, I think a letter is probably enough. Yes.
Okay. All right. Thank you.
Thank you, Romy. Does anyone else have any questions for either of the Davids? No, I'm not getting anything back. So I think we have finished. Like I say, I will send an email to everyone with a recording of the session, the slides, contact details for both Davids, if that's okay, Davids, and a reminder of some of the events that are coming up, and the expression of interest for Canterbury City Council for their promotional activities. So thank you very much. Thank you to Girlings. Thank you to both Davids. Thank you to you for joining us, and we'll see you at the next session. Thank you. Bye-bye.
Bye-bye.
Thank you. Bye-bye.
Thanks, Rachel. Thank you, David. Thank you, David.